Hi, everyone. On behalf of the Exceptional Family Resource Center, it is my great pleasure to introduce our speaker for tonight's Parenting Hacks. We are discussing the 101 of conservatorships and specifically limited conservatorships for individuals who are regional center clients. Our professional expert for tonight is Scott C. Soady, Esquire. Scott is I'm really happy to call him a friend and someone who I have seen do amazing things on behalf of not only his child, but many others. And it's just a great pleasure to have you. Thank you so much for being here tonight, Scott. And I will let you start.
All right. Good evening, everybody. Again, my name is Scott Soady. I am an attorney. I've been an attorney for about 20 years, which is too long, but here I am. I'd like to thank Joe and Moira and the Exceptional Family Research Center for inviting me to this. We've done some collaborations over the years with my other role. A little bit of background about me is, again, I've been an attorney for about 20 years. I do have two children. My youngest it has a disability. She has a rare genetic disorder that causes blindness in children, and so I that's how I sort of got involved with the disability community. I have done conservatorship work for most of my career. It's mostly concentrated at the beginning of it, however, but yes. Anyway, and as Moira mentioned, I should say at the outset, attorneys are all about disclaimers. So yes, I am an attorney. I'm not your attorney. I can answer general questions, but if you have specific legal questions, I'm not necessarily going to be able to answer those for you. I recommend that you get your own independent attorney to answer all of the questions that you may have. So with that, let's get started. Joe, if you want to get to the next slide there. All right, so the presentation is mostly going to be focused on that limited probate conservatorship. That is uh, uh, what is most relevant to this particular audience. But in order to get there, I sort of have to define what a conservatorship is and what the types of conservatorships there are. Um, so, uh, so yeah. So first is to understand very basically that there's a conservatorship of the person and a conservatorship of the estate. Um, the estate is much easier to understand. Maybe it's basically like handling the person's money, right? This person can't handle their own finances, and so a conservator of the estate would handle all of their financial aspects of their life. The person becomes much more complicated. It's much more like medical decisions. Where do they live? These types of decisions. Um, so I think we can go to the next slide, though. Right. So again, I'm trying to eliminate types of conservatorship so that we can narrow down into the limited conservatorship. An LPS conservatorship, you do not need to know what LPS stands for because it stands for three legislatures in the 60s that passed this legislation. That's it's literally their names, but it's LPS. The point of this is for specific conservatorships for those with mental health diagnosis. That The definition is that they are greatly disabled or unable to provide for their food, clothing, and shelter due to a mental illness as defined by the DSM. Are they on six now? Anyway, it was five when I was doing this work. So anyway, but yeah, you have schizophrenia, you have bipolar disorder. There's some mental illness that's happening. This allows the conservator to be placed in a secured facility and be treated involuntarily with antipsychotic medication. Almost most importantly, this cannot be initiated by the family itself. This has to be initiated by the county mental health director. Um, and there are other things involved, and it's an entirely separate system. But basically, if your child or family member has a specific mental health disorder, then this is the type of conservatorship that you actually might need, or the person might need. But but otherwise, not really what our focus is going to be tonight. So we're going to move on from there. Next slide, please. All right, so this is where we have again, just to try and narrow down the focus, or the filter down. So, what is a conservatorship? A general conservatorship is, for the person, would be a person who's unable to provide properly food their personal needs for physical health, food, clothing, and shelter. And for the estate, it's a little bit different because they are substantially unable to manage their own financial resources or resist fraud or undue influence. And so a conservatorship of the person or estate can be established for those who meet that particular criteria. The most common you see this, a general conservatorship, is for, if you imagine an elderly person who may or may not be diagnosed with dementia, but basically they've progressed to the point where they're unable to provide for their own needs, and so they need some assistance to do that, and there's no other possibility other than a conservatorship. Specifically, there can be dementia powers that are also accompany this. This allows, if a person is diagnosed with dementia and you get a specific dementia conservatorship powers, you can place that person in a secured perimeter facility and also treat them with antipsychotic medication. Again, this is all just a general background of conservatorships to get to what we actually want to focus on, which is the limited conservatorship, which should be coming up next. And before I get there, I just want to say, is there any questions on the opening of all of this
There are
before
no
I go further?
questions.
Okay,
There's no
very good.
questions in the chat. I think everyone's waiting for this particular slide, and then
Right.
the
Okay.
questions shall flow.
Okay. So then, yeah, so really what we're focused on is what is known as a limited conservatorship. It's a little bit of a misnomer because you actually can get more powers than you would otherwise get in a general conservatorship. I don't really know exactly why they called it a limited conservatorship, other than you have to ask for specific powers to be granted. A limited conservatorship is only for a developmentally disabled adult. We'll define what that means on the next slide. And again, the purpose is to provide more independent, productive lives for them. This is sort of familiar language, hopefully, with you for like IEP language and transitional plans. How are we, even though a conservatorship is established, the purpose is to provide them with as much independence as possible, even with the disability. Um, that said, if the disability is severe enough, you can qualify for a general conservatorship. Although, having recent experience, I was sort of told by a judge that, like, even though that the conservatee is quadriplegic, blind, nonverbal, like every disability that you can imagine, they still wanted to live in conservatorship. So I put that in there of like, that's what the law says, but the judge said otherwise. And so I had to refile as a limited conservatorship. Anyway, moving on from there. So, next slide, please. Right. So a developmentally disabled person is the disability has to originate prior to the age of 18. So there's the diagnosis of autism or anything on the autism spectrum, cerebral palsy, any number of other disabilities that sort of appear during childhood. Obviously, there can be conservatorships for adults that don't have a developmentally disabled. Like I've had cases where they were in a car accident, or there was a coma, or there, some sort of, brain embolism. Embolism? No, that's not the right word. Anyway, they had a stroke and became disabled as an adult. What we're talking about is the disability is originated in before the age of 18 and is expected to continue for the rest of their lives, right? This is not it's not something that they're going to ever recover from, really. And so it constitutes a substantial handicap. And the definition specifically includes the definitions of intellectual disability, cerebral palsy, epilepsy, and autism. Um, does not include physical disability. So my daughter, who is blind, would not necessarily qualify for a limited conservatorship because her disability is purely physical, has nothing to do with her mental faculties or her ability to make decisions for herself.
And if I can just
Ex-
pop in,
Sure.
this slide actually is also some of us with children that are in the regional center will recognize that this is a very close match, if not an exact match, for what is the eligibility for status 2 under regional center. Go ahead, Scott.
Right. And I think that might be, and you can go to the next slide, but yeah, basically, if your child receives regional center services, then you should, they qualify for a limited concern. Or I shouldn't say qualify, but they are under the umbrella of that would be a limited conservatorship. Okay. So yeah, as I said, they have to have a substantial handicap. What does that mean? They have to have a limitation in three or more major life activities. So that is self-care, um, expressing language, learning disability, mobility, self-direction, capacity for independent living, and economic self-sufficiency. So these are sorts of criteria for what is considered a substantial handicap. So yeah, how I write these is what activities of daily living do they need assistance with or complete help? Like they're unable to provide for their activities of daily living in these criteria. Go to the next slide. Okay, so again, with a limited conservatorship, a general conservatorship will grant a bunch of different powers. Like just there's like a standard list of everything. Um, Whereas a limited conservatorship, you have to specifically ask for uh, each independent power. So that is the ability to fix the residence, to access confidential records, consent or withhold to marriage. In a general, for example, in a general conservatorship, the conservatee retains the right to consent to marriage. It's not a power that can be granted to a general conservatorship, whereas a limited conservatorship can actually have that power whether or not to give or withhold consent. You can control the right to contract and for over medical treatment of the conservatee, as well as control social and sexual contacts and education decisions. So, and I should have started with this, but it's important to remember that when your child turns 18, legally they are considered an adult. It doesn't matter if you've been making these decisions and it's obvious to the entire world that you should continue making decisions. At some point, you will hit a wall where some doctor or educator or someone will say, well, you're not the conservator. You don't have the right to make decisions on behalf of this adult person. So just because you've been making decisions for them for their entire lives, when they hit that that 18-year-old mark, that is a line in the sand. So unless you have conservatorship, you do not have any ability to make any decisions whatsoever on behalf of your child. So important to have these things in place. And you can apply for conservatorship prior to them being 18, with sort of with the anticipation that they will turn 18 on such and such a date, and you will become the conservator on that date. Um, so yeah,
Can I
and
throw in?
yep,
Can
go
I
ahead.
throw in Reelsville? So
Yes.
my understanding is that let's say you go to the court and you say, oh, I have a 17-and-a-half-year-old and I want a conservatorship. My understanding, though, is that the actual hearing cannot occur in advance of their
No, it
18th.
can. It actually
Okay,
can because the orders
tell us more
will.
about that.
Sure. Yeah. So you can apply ahead of time. So, like let's say when they turn 17, you should be thinking about doing this because there's always going to be some delay that happens, right? So, but yeah, you can apply. The hearing date will often be at least 2 or 3 months after you filed. So your timeline of, you said 17 and a half, right? So I'm already nervous because it's, you're at least the 17 and three quarters now. And then there's going to be a myriad of things that happen that could cause a delay. You didn't do all the things that you were supposed to do. The regional center didn't give a report. They have to give a report, but as we all know, regional centers backed up and busy doing a lot of other things. So very important to get the ball rolling earlier rather than waiting until the month before they turn 18. Um, but yeah, the order itself can specify on their birthday, the conservatorship is then put into place. So the order can be done ahead of time. The hearing can happen, and the appointment doesn't become effective until the 18th birthday. So this is the other thing is part of the hearing will be whether or not the conservatee has the ability to vote. This is usually determined whether or not they can communicate if a desire to participate in the voting process. So we're already taking away a conservatorship takes away rights of people, right? Like this is should be theoretically understandable, right? Like you're saying, like you cannot make this decision, so it's taking away rights. This is one of those fundamental constitutional rights that also has to be determined whether or not the person should be able to vote. And this is going to be a specific question that the judge asks about. There's been case law and things about that they have to very specifically ask. It's presumed that they do have the right to vote. I
Scott,
think
can
there's a
we go
question.
back?
Yeah,
Yeah.
so good.
Can we go back one slide, Joe,
Sure.
just to talk about the age issue? Um, so I guess we don't really need to be on this slide, but when we have a child that is past 18,
Yeah,
and again, Nick, I'm going to say personal experience and just lots and lots, the vast majority are not doing the Scott way where they're applying super early.
correct.
Most people are not getting that conservatorship in place for the variety of reasons that we can go into later. So the question really is just if your child is already 18, are they okay to go ahead and apply?
Yeah, there's a conservatorship can be established at any point, or at least filed, right? So, but yeah, so it very often what I see in my practice is, you know, the incredibly clearly disabled child has turned 18 at some point, and there's been never any pushback by the system or whatever, right? The one I'm currently dealing with, again, like profoundly disabled conservatee, but like the hospital was like, well, who can make medical decisions? We need to, she needs a surgery, but nobody can consent to it. And suddenly the family is like, oh my God, what do we do? Right? It's that kind of thing where you sort of you've been seeing the same pediatrician for their entire lives, and suddenly when there's an emergency or something happens where the system finally pushes back to say, wait a minute, how is anybody able to sign off on anything? That's where there's a sort of a panic, as it were, right? So often there's a crisis, and that's when it's like, oh really, we do actually need to put this in place. So um but yeah, conservatorship can be established at any point. It's just, best practices are, if you think you need a conservatorship for your child, you should think about it when they turn 16, 17, and starting to get that process begun at that point, so that you don't have the gap of time where nobody can make any decisions regarding the person. So yeah,
So we can advance a couple slides, Joe. Thanks for the pause, Scott.
sure.
And we will circle back before the end just to kind of give the alternative side of
Sure.
life.
Oh,
But
yeah,
let's keep
absolutely.
going.
Yeah, very
Keep
important.
going.
Yes. Okay, so what's the process, right? We sort of already touched on this a little bit, but um, essentially, a petitioner, usually it's the person who wants to become the conservator, would petition the court to become the conservator. You have to file a whole slew of documents. There's every time I do one, I'm like, oh my God, I can't believe there's so many of these. But yeah, There's the petition itself. There's a confidential screening form that the conservator has to fill out. There's a confidential supplemental information which provides maybe more, confidential information that the court would like to know about. You do have to have a doctor's declaration done, not necessarily before you file, but before the hearing comes. So that's another thing of like having a doctor fill out a declaration specifying what the impairment is, how severe it is. It's basically the doctor has to fill out a sliding scale of, is the person able to communicate, or uh, is oriented, and things like that. Um, you have to notify relatives to the second degree. For those who are not familiar with the table of consanguinity, which is the that is the relatives of second degree are grandparents and siblings of the conservatee. So the conservatee is the person your child or whomever is you're trying to become the conservator of. Specifically in the limited conservatorship space, you do have to have that regional center report as well. Um, the conservatee will be appointed an attorney to represent them. This is going to happen in almost every conservatorship. So an attorney is appointed by the court, is paid at the expense of the county, unless the conservatee has assets of their own. And that attorney represents the conservatee and their wishes. There's also a slight difference where the court can appoint a guardian ad litem. It wouldn't be an attorney presentation without Latin terms, so I apologize. But guardian ad litem, um, a guardian ad litem sort of acts or advises the court in the place of the person themselves, as opposed to the an attorney appointed to represent the conservatee would advocate for what the conservatee's express wishes are. Anyway, so there's a slight difference there. I can go into the nuance at that. And then everybody has to attend the hearing unless they're medically unable to attend. However, all at least in San Diego, all the courts are now hybrid courtrooms, and so you can appear via. They use Teams instead of Zoom, but like the conservatee can be on Zoom and at the home or whatever. You don't necessarily have to go in person like you used to have to, unless you were excused due to a medical reason specifically. So become a little bit easier to meet that requirement. I assume Moira can tell you her story about bringing their child to the courtroom, which
Well, and I was actually gonna, we have a question, but also with the
sure,
doctor's declaration, there is on that, I think it's that form that has a doctor gets to say whether they believe the person who's being proposed for conservatorship is able to attend. So, as Scott is
correct.
noting, unless medically unable to attend, medically often includes the umbrella of behaviorally unable to attend and participate. So that's my parent to parent, non attorney uh, gouge. But we have a question. How
Okay.
about if grandparents are overseas, don't speak English, and are not readily accessible? Does the court care, Scott?
Yes. Absolutely. Doesn't matter. Notifying is just simply sending them the form with the paperwork to their address. That's it. Like they don't have to like sign off on anything, but yes, to the extent that you know where family members are, you must provide them notice. I don't care that like, well, the father is, a criminal and he's on the run and he's in Mexico. You have to notify them. If you don't notify them, then you have to get permission from the court to waive the notice for any reason, any number of reasons. But it's a very hard hurdle to jump over, right? So notify everybody. Does not matter how involved they've been in the child's life or not. Notify. You have to notify the world, and the world in this case is siblings, grandparents, doesn't matter. You also like deceased. You have to say the grandparent is deceased. they're right, like you can't just like nah they're don't exist anymore, right? You have to specify who they are, say they are deceased and don't require notice anymore. But yeah, you have to list everybody, doesn't matter what their involvement is.
And since we're on this slide, I'm going to add a little other fun fact, which is you'll see the conservatorship process includes this regional center report. I've certainly seen, and there may even be somebody on this call who has come to the great state of California and they're coming from another state. Their child has not yet gone through the regional center process. They come in with their own guardianship intact. And guess what? Scott, tell what happens next.
Oh, geez. Well, I'm not even sure actually, because so first of all,
I'll give you a hint. There's an
well, yeah,
expectation that you go to regional center and go
sure.
through the process. So,
Right. I was going to say, like, there's a whole thing. You can't file for conservatorship unless you've been in the state for 6 months. So, like, there's the whole other aspect to that. Yeah, the court does not have jurisdiction over the child unless they've been here for more than 6 months. And yeah, typically when you come to the state, you have to terminate the prior guard. There's a handover. Anyway, it's a whole thing. I'll sort of cover it later in a little bit, but yeah, you got to start the process all over again.
which is, I think, part of this consideration that we'll get into later, trying to
Yeah,
make this a little conversational, is, there are reasons that you might not be like racing for the, age 18. And so we'll cover that later.
right.
Slide
And
Joe.
yeah, I just want to point out for the Moira mentioned just sort of like the behavioral aspect of medical. I'm not practically. I'm not sure. I think that the judge in the court really wants to put eyeballs on the person and try to talk to them directly. Behavioral, if you go to the conservatorship calendar, which is usually 10 o'clock on 10 o'clock, 10 a.m. on Thursdays. If you go to the court, then um,
Most people will have them. Most people will.
right. What I'm
Yes.
saying is the court already has an expectation that this is these are the types of cases we're hearing, and so they're much more lax. I wouldn't say lackadaisical, but they understand the behavioral challenges, and they're not expecting like perfect behavior on that. At that time, they expect a little bit more interruptions and things like that. So, but yeah, the court takes it very seriously that we are taking rights away from this person, and so they really do. The judge really does want to speak to that person directly, whether or not they're shy or don't want to talk to anybody or anything. The court will do its best to interface with the person to say, I hear your favorite show is puppy dog. What I can't remember the thing anyway, but
Paw
whatever their
Patrol.
favorite.
Paw Patrol is what you're
Thank
trying
you.
to
I
do.
was like, it went out of my head, and my kids never watched it. Thankfully. But anyways, like I heard your Paw Patrol is your favorite, or oh, you're wearing a SpongeBob shirt today. Is that your that kind of thing? So they will try to interface with the conservatee to try and as best they can to make it as comfortable a process as possible. So um, anyway, we can go ahead to the next slide. All right, so yeah, so once you're appointed, assume if it's just a conservatorship of the person, again, just like you're only making those decisions about where do they live, where, medical decisions, that sort of thing. There's not really any need to go back to court for any reason, right? There's just a periodic review. The court investigator will come out to see you occasionally and say, is everything going fine? Is the conservatorship still necessary? All of these things. And that happens about, like every 2 years or so. Um, if there is a conservatorship of the estate and you're actually dealing with money, then there's an accounting that needs to happen uh, it's after the first year and then every 2 years after that. Um, you must inform the court if you change your residence within 30 days, and you cannot leave the state. That's the other thing. You have to, right? Like you have to get permission from the court to even move to a different state and then establish a conservatorship in that new state and then terminate the conservatorship here. It's a whole process. Just
For clarification,
yeah,
Scott,
mhm,
people can leave the state on vacation. They just cannot
absolutely
domicile us. Okay.
correct. Yeah, I apologize if that was unclear, but yes, it's I want to pick up, move to Arizona instead. Going on vacation, that's fine. Like your intention is to return to your home in California. That's not a problem. You don't need the court's permission for that.
Thank you.
Okay. All right. I think we can move on. All right. So and we maybe should have started here, but here we are. So the I, a former mentor of mine used to call conservatorship a legal death. Like the person that is being conserved is all of their rights are being taken away. They basically don't aren't allowed to make any decisions whatsoever. So it's really only reserved for like the if there's if disability is a spectrum, and we all know that it is, right? It's supposed to be reserved for um those that really cannot make decisions on their own, right? So that's what conservatorship is for. Um, because there are so many other alternatives to conservatorship that you should try ahead of time, right? So one is a power of attorney for finances. So you to help me with my bank account stuff, right? Like it's just that simple. They're able to communicate otherwise. They don't need a conservatorship per se. They can sign a power of attorney. um, it can be an immediate power of attorney. It can be a springing power of attorney. A springing power of attorney means that if they are determined to be incapacitated in the future, then it would come into play. But if we're talking about alternatives to conservatorship, it should be an immediate power of attorney. They are basically granting access to talk to banks or whomever, or access their finances, or talk to Social Security on their behalf for any of these things. Same with a healthcare directive. This can also be done immediately. This is I authorize this person to make healthcare decisions for me. Um, the issue with both of these things is that they can be revoked by the person who made them in the first place. So if you have a falling out or a fight with your child, they can say, "I don't want you to make decisions for me anymore." The conservatorship is much more permanent. It can be terminated, but it's sort of without court order, it cannot be changed. Whereas the power of attorney and the healthcare directive can be changed almost, I wouldn't say on a whim, but yeah, I think you understand my point. So, um, other things to consider is a special needs trust. So if your child is on any sort of government benefits, what I mean by that is Medi-Cal, SSI, Social Security Disability. Sometimes the any money that they inherit or that you want to give them should be held in a special needs trust so that their benefits are not affected by anything that they might inherit from you. This is basically a special needs trust establishes that the money is held for them in a trust. The trust cannot pay for their food or shelter, but can supplement any other thing that they need. It's very bizarre, but like you can buy them a television or a motorcycle or a car or any number of other things. It doesn't affect their government benefits, but and they can continue receiving those. But yeah, the money can still be used for their benefit for other things that are not the food or shelter.
And I'm going to
I
just
think there were
pause.
some questions. Go ahead. Yeah.
I was going to just pause and say that, hopefully we'll be able to beg Scott to come back and maybe do a special needs trust 101, just because that topic in particular is so
Yeah,
thorny and has so many, ifs, ands, or buts that it probably deserves its own 101. And I am putting into the chat just a few resources related to this slide, Scott, that people can click on if they want more
perfect.
information.
Okay. And yeah, the other thing is like you don't want to do a whole special needs trust for them. There is what the relatively newer thing is what's called able accounts. So the issue before was that a lot of people with disabilities were unable to because the income threshold and the amount of money they could have was so low, it's for qualifying for Medi-Cal is less than $2,000 in the bank. They weren't able to save up money, and able accounts allow them to at least save some money up to $100,000 at a time. So that's another alternative as far as the economics go for if they have any finances or anything like that.
And I'm going to just also pipe in with a very newer. It's been around, but it hasn't been really formally introduced into like the societal institutions that actually are usually the pushbackers, as Scott referred to them. Like you kind of squeak by, and then finally somebody says, nope, we're not doing that. So there is a model that is called supported decision making. It is starting, I think, to gain some traction. And there is actually, I think, a question now, Scott, and I'm looking to you because I know you fill these forms out more than I do, but I think there is now a kind of a requirement, at least in the regional center write-up, to consider whether supported decision making is a reasonable or suitable alternative. Again, I would say if the folks listening have been in the special education system, you have this idea of least restrictive environment. Like, what's the very least restriction that we need to put on a person that allows them to meet their goals? And so, supported decision making is kind of like, I would say, right, pretty close to general education with a little, pull out. It's a very you have supporters. There are some protections put in so that supporters cannot have, liability or get into legal trouble for being your supporter. But I think there's still some things to sort out. And certainly it's not an exact match for a conservatorship. But I just wanted to put that out there. So if you hear about it, I have dropped a link in the chat. But Regional Center, if you are going through this process, we'll probably try to have a conversation with you about this and just want to hear like where would this not work? And it's just a consideration right now. Thank you.
Yeah, and I'll echo the point a little bit, which is that on the court forms that you have to submit, you have to say what alternatives to conservatorship have you tried, or why are they unavailable, right? And so you have to really do. Again, this is for uh, you know again on the spectrum, the more severe spectrum of things, right? So you have to go through methodically of like, well, we can't do a power of attorney because this reason. We can't do a healthcare directive because this reason. We can't do we can't do all of these things because there has to be a reason why, right? Um, because otherwise, it's I I try to have this, it's easier to have this in a in-person
In
context, but
person,
like,
absolutely.
yeah. So, but the idea is like every parent would love to make decisions for their child after they turn 18. But just because you would like to doesn't mean you should or can or should be able to. Think back in your own lives. Did you disagree with your parents about what you wanted to do with your life? Maybe, right? And so if they had the legal authority to make decisions for you, you might have wanted some pushback about that. So yeah, again, it's not, I wouldn't say it's not a last resort, but it's a very severe imposition on the person and can be very infantilizing, right? You are taking away their ability to make life decisions that they would otherwise might want to make. So very important to consider any alternative that you could do before that. So, all right. And that's the end of my presentation. So that's my contact information, my office, and you can reach me if you'd like. But otherwise, I'm happy to open it to questions and answer any specific things that anybody wants to, not too specific, but